Have you ever seen the cartoon comedy Harvey Birdman, Attorney at Law, which features a paralegal in the form of Avenger? Well, if you have, you can recall Avenger accompanying Birdman into court and whispering case information and advice into his ear because Birdman was underprepared. You might be wondering, what does Harvey Birdman, attorney at law, have to do with developing the next generation of paralegals? Well, I tell that story because it illustrates the role of a paralegal in litigation. My name is Natalie Dyke from Law Office Management Group C, and the other group members are Barrington Pitts, Georgette Hanley, Kahia Cummins, and Samantha Melville. And today, we will be sharing with you the role of the paralegal in litigation.
So firstly, let's discuss what is a paralegal and how the paralegal profession was born. So the American Association for Paralegal Education, or AAFPE, they describes a paralegal as someone who performs substantive and procedural legal work as authorized by law, which work in the absence of the paralegal would be performed by an attorney. Now, in briefly discussing the birth of the paralegal profession, in the 1960s, it took the American Bar Association to realize that the incomes of attorneys were below those of other professionals. And they thought that to increase attorneys' efficiency, that would then increase their incomes, and paralegals would do this for attorneys. So when discussing what qualifies paralegals to perform legal work, it is of course essential that they have knowledge of the law, and this is usually gained through education or experience, or education and experience. Paralegals usually operate in the same areas as attorneys. However, there are some specialty areas for paralegals, and they are like corporate, estate planning, and probate, family law, government, immigration, intellectual property, litigation, and real estate. The entire litigation process, paralegals are considered invaluable to attorneys. Litigation paralegals are considered the backbone of the trial team. These paralegals cover all the details involved in the entire trial process, from trial preparation straight to post-trial work. Some of the subspecialties that are covered by litigation paralegals, which we mentioned here, are like bankruptcy, personal injury or corporate or intellectual property. The duties and responsibilities of a litigation paralegal are endless. However, here we mentioned a few, such as preparing for trials, overseeing discovery, research, pre-claim investigations, settlements, appeals, and interviewing witnesses. These are all covered by litigation paralegals. These are all their many duties and responsibilities, or just some of them. An investigation would usually kickstart all civil litigation cases. Litigation paralegals would then take the lead in the pre-claim investigations. To ensure that the case is well established, paralegals would take the responsibilities of doing the necessary investigations. Some of the paralegals' role, as mentioned in this PowerPoint, are interviewing witnesses, taking witness statements, locating witnesses, gathering documents and evidence, creating case investigation notebooks, and so on. Now moving on to pleadings. Pleadings are usually documents that explain the basic arguments of either side of the legal issue. There are, of course, litigation paralegals on both sides, that is, litigation paralegals on the plaintiff side and on the defense side. Paralegals on the plaintiff side, they may assist in drafting pleadings, including the summons, complaint, and supporting affidavits, while paralegals on the defense side collaborate with the client to investigate the allegations and formulate responses.
Okay, so the next two steps we'll be talking about in the litigation process will be discovery and pretrial. So in the discovery process, this is where the paralegal has the role and responsibility to ensure that they know everything there is to know about the case. If this means they have to go read law books or go into law library and look for cases, look for legislation, whether they have to go and conduct interviews with witnesses or associated persons, whether they have to go get advice from other legal teams, this is where the paralegal has to ensure that they know as much as they can about this case. So when they go to the rest of the legal team, them and they could all sit together and discuss the different outcomes, the different successes, any failures, what they'll need to know to ensure that they have a positive outcome on this case. Basically, discovery is where they have to make sure they understand the case inside and out to ensure that they know this case really well. Next step will be pre-trial. During this process, this is where they have to ensure that the trial runs smoothly. This is where they have to do all the necessary tasks, all the preparation to ensure that everything is ready for them. To ensure that the trial runs smoothly, this is where they have to make sure that they have all the documents ready at hand, any exhibits, any items, any PowerPoint presentations, everything is well and organized, so when they're ready to use it, they won't have to be looking and having to be flustered and have to cause a disruption or any kind of hiccups in the case. This is where they also have to make sure that where necessary, any hotel rooms or any places of accommodation that they need to have to make sure that they're there, so that when the trial day has arrived, everything runs smoothly without any problems.
Following the pre-trial stages of litigation, there then comes the trial stage of litigation. Now, as we know, this stage involves both attorneys, whether for the plaintiff or the defendant, attending court to argue the position and validity of their case in the presence of a judge or jury. At times it could be a judge alone or both the judge and jury. Now, in this stage, the paralegal should be taking all the necessary and relevant notes during trial for his or her own attorney to use as advantage when times come. Notes could include the statement of witnesses when called to the stand, information given by the judge, or information presented by opposing counsel during the trial. Now, with all the notes and information being obtained, the paralegal must then organize all the relevant documents according to relevancy and presented it to his attorney, because if nothing is organized, then it's useless at time. The organization of relevant documents will help in the readiness of the attorney when times come. At times, paralegal could be seen preparing witnesses. Those are witnesses with relevant information pertaining to the case, because as we know, all witnesses need the proper preparation, as if they're not prepared, the opposing counsel could drill and press matters to find inconsistency in statements made by witnesses. Henceforth, the paralegal prepare all witnesses brought or called upon to attend trial in a case. There then is the settlement stage of litigation. At this stage, both the claimant and defendant reach an agreement that could be settled outside of the courtroom, because as we know, if not known by now, litigation is very expensive and could sometimes be unfair to a party. So, depending on the situation that arises, it's best to settle outside of court. Now, as we know it, settlements need to be negotiated thoroughly, and both the paralegal and attorney negotiate with the aggrieving party on either the terms and condition or payout to the grieving party. Thereafter negotiation in the settlement stage, the paralegal will be tasked to draft the necessary documents regarding the agreement, and yes, the payout.
In concluding, it can definitely be said that the foregoing discussion has successfully outlined the role of the paralegal in litigation. Hence, It is now clearly understood that a paralegal, given the definition stated, is, as it were, the right arm of the attorney and must possess the necessary skills for the attorney to be successful in litigation. He or she must be able to communicate not only in writing and in the verbal sense, but must also be able to meet and conduct interviews with the relevant parties, especially the clients. Research must be thoroughly done in the initial stages of the case to discover the facts and issues needed. Investigation is a critical part of the paralegal's role to identify hidden or concealed facts. The use of technology is paramount in order to be competitive and on the cutting edge. There must also be the ability to multitask, be a good team player, and pay great attention to details. The paralegal is indispensable to some extent, as most of the administrative matters are placed in his or her hands. He or she has to manage the whole workload. For example, they have to take initiatives in drafting, pleadings, and investigating before, during, and after trial. The matter of settlement was also highlighted. In this aspect, the endeavor is to avoid having a trial and bring some resolve between the parties. The paralegal again is the anchor here and gathers and organizes relevant information. The paralegal must creatively design and make settlement vouchers, which may include videos and graphics. Additionally, distribution statements must be prepared and sent to all the parties by the paralegal. Furthermore, if the case is lost, the same paralegal will have to commence preparation for the appeal. Finally, and henceforth, it can definitely be said that the foregoing discussion has successfully outlined the role of the paralegal in litigation.